Hi, everyone. My name is Raleigh Seamster, and I'm a program manager with Google Earth Outreach. I'm really excited about the guests we have here today. I'd like to introduce to you Cris Stainbrook, who's the president of the Indian Land Tenure Foundation. And he's here today to talk about the past, present, and future of Indian lands in the United States. Please welcome Cris.
Ihani Washde, Cris Stainbrook, Himachiapi, Padame Raleigh. Good afternoon, my name's Cris Stainbrook, and thank you to Raleigh for inviting me to do a Google Talk. You can tell by my Southern Lakota accent that that would make me Oglala, and I'm sure you're familiar with that, right? So today we're going to talk about Indian land, and Indian land specifically in the United States, the lower 48. We won't talk about Alaska because the land issues are entirely different up there, although they do share some amount of commonality. Most of our work has been limited to the lower 48. The foundation itself started nearly 16 years ago, and we started with a mission, and then those areas outside of the boundaries that have special meaning to the tribe still, either for cultural reasons or religious reasons. This is Indian land before the coming of the Europeans. It was the entirety of the continent, about 800 different tribes, and went from sea to sea, basically. Then we had the early immigration period where we had the 13 colonies established and the Europeans coming onto the shores, and that went through pretty much the late 1600s. And then we started getting even more pressure from Europeans and others coming to the shores on the east. And eventually it led to President Andrew Jackson declaring that all Indian people should be removed from the east, at least to the Mississippi River. And in fact, that's when Oklahoma, what's now the state of Oklahoma, became Indian country. And they removed people from the eastern tribes to Oklahoma. That's why you see the tribes in Oklahoma today being the same ones that were on the East Coast. In theory, but not in practicality, the land rights of those tribes in the East Coast were eliminated or eradicated. Then we started getting people coming on the West Coast. We had the Hudson Bay Company. We had people looking for gold and furs and others. And we started getting pressure in Oregon and California specifically, but also Washington State to a lesser extent. It was also in 1803, of course, we had the Lewis and Clark incursion up the Missouri River and over the Rocky Mountain Divide and into the Pacific Northwest. All of this kind of got to a point of what's called manifest destiny. So it was this notion that all the immigrant folks had about they were destined to take over this country. You can see by this particular picture, you've got this angelic figure, of course, stringing the telegraph wire. You've got the bears and Indian people in Buffalo running in fear further west. And you get the railroads coming in, you got industry, as it were, pushing people out of the land, which then led to any number of Indian wars and settlements and peace treaties and other treaties that were primarily land cessions to non-Indians. And today this is largely what you would see if you looked at a map of the treaties that were done through 1871, which ended the treaty making period. One thing I would point out, and this map needs a little work, I was showing this at the Crow tribe. I was showing it to a family of folks who wanted to work out an agreement with the Crow tribe around land that they owned. And I popped this slide up, and unfortunately, if you look at the southeastern boundary of Montana, the Crow Reservation and the Northern Cheyenne Reservation were left off the map. And now they blame that on me being Oglala. You know, it was just an oversight. What can I say? if we want to summarize the land loss up to that point, it's easy to do it up until 1887. So in 1871, the federal government quit making treaties with tribes. And after that, reservations were established by executive order only. There were a number of those between 1871 and 1887. In 1887, the reason that's important is because that's when Congress and others decided that Indian people should become farmers and ranchers, much in the European mode. So what they did was they passed the Dawes General Allotment Act. And the Dawes General Allotment Act said the reservations would be allotted to individual Indian people in 80, 160, or 320 acre allotments. And on those allotments, Indian people would learn to be farmers and ranchers. And all the tribal lands would basically be extinguished at that point. At that date in 1887, we had 130 million acres of land inside the reservation boundaries, and almost every treaty reads for the exclusive use and occupation by Indian people. And there was an acre or two set aside for the blacksmith, there was an acre or two set aside for the school marm, and there was an acre or two set aside for the agency. Other than that, it was to be entirely reserved for Indian people and their use. By 1934, when the Indian Organization Act passed to put an end to the allotment process, it was recognized by a 1928 Merriam report to Congress that said the Allotment Act is an abysmal failure. It's created poverty, and Indian people have not become farmers and ranchers in the mode that they anticipated. And so at that point, they stopped the allotment process. And basically, we had 48 million acres of land left inside reservation boundaries. The rest had been alienated to other ownership. And I can give you a quick breakdown. The 90 million acres that were lost, about 60 million got lost immediately. 38 million went to what's called ceded to the federal government. Once they did the allotment process at each reservation, if there was land that had not been allotted, so they did an allotment to every head of the family, and if there was land left over, they declared it in excess of Indian needs, and the federal government took it. And so that was the big loss. That was 38 million. Actually, that was 60. The other 22, they were open to homesteading. And so 22 million acres was open to homesteading, and immigrants moved in. The land that went to the federal government was held or sold. So it either went to timber companies or railroad companies, mining companies, or the federal government retained ownership if no one else wanted it. So that's where the land went. And then we lost 30 million acres through a whole host of other means, usually sale. So Indian people would get impoverished. They would be buying commodities at the agency store. And in order to pay off their bill, they'd end up selling their land interest to the store. The other way, a couple of other ways that land was lost is the Dawes Allotment Act had a blanket declaration of all Indian people and tribes as incompetent to handle their own affairs. And when they did that, they converted the land title from Indian ownership to federal trust ownership. And the federal government holds land in trust for those individuals. This was, and for the tribes, any land that was left to the tribes. And so the federal government then oversaw those pieces. Starting in 1903, the federal government decided that some Indian people should be declared competent to handle their own affairs. So, for instance, if an Indian woman married a non-Indian man, she was declared competent. And some of you may have seen the movie that just recently came out. We lost lots of land in Oklahoma because Indian women married non-Indian men, and then within a 6 month, a year period, met with an accident. and we lost lots of Indian women, and we also lost lots of Indian land. The other way that really hits a little closer to home, and especially it happened in the upper Great Plains tribes, is Indian men could be declared. Oh, I should first go back and say, if an Indian man married a non-Indian woman, that was seen as kind of lateral incompetency. I'm sorry, but that's just the way it was then. So an Indian man could become declared competent if he joined the military. And so in World War I, we had any number of Indian men who were warriors by nature signing up and going to the military. And what happened when they did that, they were declared competent. They would come home 4 years later and find out that they had been declared competent and the taxes had started to mount on their what they thought were trust lands. But since they declared them competent, they had become fee land and taxable by the county. And so while they were fighting at war, the county sold their land on the courthouse steps, basically, through a tax sale. And we lost millions of acres that way. They're called force fee patents. So by declaring the incompetency of the federal government or of Indian people and dividing the land, in doing all that, it never occurred to the federal government that allottees would die. And so the original allottees started to die, and there was no way, no mechanism, because they were declared incompetent, to handle their estates. And so they had to come up with a process, and they came up with a process that said the land will remain connected, but the land will remain intact, but we'll divide the ownership interests as we go down the road. And eventually, you know, all of the land will somehow, in essence, end the holding of the tribe. And so Teddy Roosevelt in 1901 declared the General Allotment Act a mighty pulverizing engine to break up the tribal mass. I mean, this was an attempt. The Dawes Allotment and all the allotment processes were arranged so that eventually the tribe no longer exists. And that was the intent of the whole direction of the country at that time. And Teddy Roosevelt was a big believer. So what did the allotment process look like in practice? This is the Salish Kootenai Reservation, a flathead reservation in northwest Montana. Two tribes were there, the Salish and the Kootenai, when that in the 1855 Hell's Gate Treaty set it aside. You can see the green portion is all tribal ownership, and you can see the entirety of the reservation is under tribal ownership. Allotment process came in late 1900s, and in fact, in 1908 and 9, I think, was completed. And so this is the yellow in the valley there, and up there were the Salish people were more mountainous people. If you know this area at all, you know there's a mountain range that runs down the east boundary and a mountain range that runs down the west boundary, and down toward the bottom is essentially the valley outlet toward Missoula, Montana. But those were the allotments. They were selected by the families themselves. So then it gets opened up to homesteading, and all of the white, all of the gray, all of those other squares that are on there, the purple and others, were taken from the tribe, even though this land specifically was reserved for the exclusive use and occupation by Indian people. Since that time, they've lost a little more land, but they've also been buying back land and beginning to get it back into tribal ownership or members. I think this is one of those pieces that deserves a little noting. The big purple circle in the bottom is the National Bison Range. It was established at the time of, well, just after Teddy Roosevelt was president. Interestingly enough, the Salish Kootenai folks had a buffalo herd for years and years in their area. And the only way they saw to save it from non-Indians killing all the buffalo is they sent their buffalo to Canada and raised them up there. when they established the National Bison Range, they brought their buffalo back down to the Bison Range. For the past almost 20 years, the tribes have been trying to take over management of the Bison Range from the U.S. Fish and Wildlife Service and have been fought tooth and nail, even though it's their land and their buffalo. This is a more egregious example of what happened under the Allotment Act. This is the Leech Lake Reservation in north central Minnesota. The little red dots you see over that map those are tribal and individual trust lands. And that's all that remains of their ownership on the reservation. All of the rest of the land is owned by non-Indians. Largest landowner on the Leech Lake Reservation is the federal government through a national forest. Second largest is the state forest. And then after that, it becomes municipality and then other non-Indian individuals. You can see that that's a very small piece of land that the tribes and Indian people actually own. Even though if you drive up on the highway, there's a big sign on every highway that says, you're entering the Leech Lake Reservation. And people think, wow, Indian people have all this land. It's pretty impressive, but that's what we find. As I said before, there was no real process for inheritance, and they had to develop one. And so they developed that piece where it said, we're going to hold those allotments intact and the title will divide among the heirs. And their first efforts at this were not very good, but they looked kind of like this.
Going back to the Allotment Act, my great-grandparents might have picked up a 160-acre allotment or 640 acres. When they passed on, and let's say they had 4 children, those land interests were divided by 4. And when those people passed on and they had children, the land was further divided. And if there wasn't a will or some mechanism for allocating the land interest, over and over again, you had a continued division into smaller and smaller pieces. So take a pie, divide it in half, divide it in quarter, divide it in eighths, divide it in 16th, 1/32, 1/64. All of a sudden, how much a piece of the pie do you have? You don't have a lot of piece of the pie, but you still have an interest.
We have allotments with more than 5,000 owners on 80 acres. Now, there aren't very many of you in the audience today, but can you imagine just taking this audience and sitting down and saying, what should we do with our land? Then think about doing that with 200 of your closest relatives at Thanksgiving. And then think about it in getting a gymnasium and bringing 5,000 of your relatives, some of who you're undoubtedly not even familiar with, to a gymnasium and sitting down and saying, should we lease our land or what should we do with it? Well, what happens is it by default starts getting managed by the Bureau of Indian Affairs or others, or it gets sold. And that's where we're at today. We have, from some information we received from the Department of Interior, we have one woman who's 45 years old and owns 345 undivided interests on 4 different reservations. But you total it up and she owns about 80 acres. And we have 1,000 landowners who own 100 interests or more, some on as many as 12 reservations, and some where that 100 undivided interests doesn't add up to more than 1,000th of an acre, which essentially is a 5 by 5 inch notepad. It's a chaotic morass, if you will, and it's up to the Bureau of Indian Affairs to manage that. The problem we have, the fundamental underlying problem we have, is that all the tribes had very much a land-based culture, where you were open and free to exercise your activities on the land, and that's why it was important for the tribes when they negotiated treaties to maintain that access to property, both around the reservation as well as in it. There are homelands. Clearly there are homelands. the other piece that sometimes gets overlooked in just having those reservations is that people were often moved from another site to that reservation, removed from an area that was given up or ceded to the federal government. There are religious sites outside of the reservation boundaries where the tribes still maintain interests. On the Columbia River, they're fishing sites. In the Midwest, they're promontories, and what's called Devil's Tower, Bear Butte, some of those places where the tribes gathered for Sundance and other activities. In the Southwest, you've got major canyons and other areas that are have some feature that drew the tribes there, or had some amount of importance in terms of trade. So in the Pacific Northwest, you had what's called the old Seneca Racetrack. It's in east central Oregon. The tribes from both the Intermountain West and the Pacific Northwest gathered there. They'd have horse races, but they would trade. And that's where obsidian began to move from the Crater Lake area to the plains, was through that trade corridor. So this is our vision of where we want to go. We had a gentleman in our office one day who was an artist, and he was asking if he could do some work for us because he needed a few dollars, and we happened to walk by that earlier picture of Manifest Destiny. I said, well, you could paint our version of this. And I was kidding him, but he did it. So you can see we got our own angelic figure picking up the telegraph wire. We've got that accomplished pretty much. But we've also got pipelines laid down, the railroads there. But you can see our vision. We know we aren't getting all of our land back. That's not our intent. What we want is what was promised to us. Those lands inside the reservation boundaries that were promised to us for the exclusive use and occupation by Indian people. The foundation pursues 4 strategies: education, economic opportunities, cultural awareness, and legal reform. And I'm going to go through some of these fairly quickly. So one of the things that we started with was education. We did that because Indian people, as well as non-Indian people, know very little about Indian land. In Indian country, we've been separated from that land for so long that we aren't even sure, most people in Indian country aren't even sure, how did we get in this situation? If you ask some folks, they think that it's part of the treaty that we have allotments. They think it's a treaty right to have that allotment, and it's not that at all. We get folks to understand that. One of the big pieces, because of that fractionated ownership that I described to you, we've been writing wills for Indian people since 2003. Part of the reason we do that is there's no history in Indian country of writing wills and passing your interests along. Because we were declared incompetent until 1903, we weren't allowed to write wills. And in fact, it wasn't until 1924 when Indian people were recognized as citizens of the United States, a will wouldn't hold up in court. And so there was no history of that. Our best guess is 7% of Indian people have wills. And we've been trying hard to get that up. We also do strategic land planning with the tribes and others on a regular basis. We put out a message runner on a I would say a periodic basis on various topics that Indian country needs to know about. But this one was one of our first ones, and we've got one since then that's really about the general public, and you can find those online. The other thing we did was we asked ourselves, so our mission is one of 150 years. That's our plan. We aren't going to be around to see 150 years. And so we ask ourselves, how do you get a movement started? And one of the things that we looked at was the non-smoking movement, the recycling movement. What were those at the heart of those? And it was the kids, right? So the kids, you get this message across to them and say, you don't want to start smoking. And they would take that home to the parents. And so that's where we've started. We have a K through 12 curriculum. We have a college curriculum, and we were approached about doing a Head Start curriculum. In fact, we have a coloring book now for Head Start on Indian land. Our curriculum is in it's in all the states of Montana, or all the schools in Montana. It's in most of the schools in South Dakota now. And it's in, I don't know what the count is now, 50 or 60 schools in California. Primarily Southern California, and then very Northern California up in Yurok and Round Valley. The other thing we did on a lark was a gentleman came to our office one day and said, "I want to help you." And we said, "Well, what do you do?" And he said, "Well, I'm in the entertainment industry." And we said, "Okay, but what can you do for us?" And he said, "Well, I'll help you raise some funds." And we said, "Well, we aren't ready to raise a bunch of funds." And he said, "Well, I can make a movie for you." And we didn't know him from Adam. Our support person out front said, "Was that Barry Zavan, the weatherman that was there?" And it turns out he was the weatherman in the Twin Cities for a number of years before he went to Washington and New York. He was back. He gave us a good price on doing a film. We did the film. He arranged to have Sam Donaldson narrate the film, and it turns out that we won the Telly Award that year for documentaries, and we've been happy ever since about that, since we knew so little about it. They called us and said, "You won the Telly Award," and we said, "What's that?" We have a Buick hood ornament, or I should say it looks like a Buick hood ornament. This is one of the big pieces. Every time the federal government realizes they have a problem with fractionation, the way to solve it is put it on Indian people. And so in 2004, the American Indian Probate Reform Act passed, and it basically set up a process that if Indian people don't have wills, they lose control of their asset. And the federal government decides how their asset will go to be divided among their heirs or not. We are going to lose a whole bunch of Indian land 3 generations out if we can't get people to write wills. So we spend an inordinate amount of time trying to do pieces around the American Indian Probate Reform Act. Then we also work on using land as an economic asset. How do you leverage your land ownership? How do you use that land to be productive and make a living off of it? And we've done a number of things, including acquiring the alienated properties inside the reservation boundaries, and also helping some amount of agricultural businesses get started, because ag, of course, is the most tightly connected to the land. And in the Great Plains, it takes large acreages in order to make a living. So we've been working on doing some buffalo operations, which require astoundingly large tracts of land. We also have a subsidiary, the Indian Land Capital Company, and it lends to the tribes in full faith and credit. We don't take collateral from the tribes. We don't take land as collateral. Once they have that land back, we are not going to put it at jeopardy again. We wanted to demonstrate that, in fact, the banks should be lending to the tribes on full faith and credit. On the other hand, they seemed reluctant to do that. But what we've demonstrated to them is that, in fact, you can do this, and the tribes will repay the loans. And we have not had a default. We've had one tribe get in trouble, and that was a loan that we rewrote for them, and they paid it off early. The other thing that's become interesting is much of our early capitalization for Indian Land Capital Company came from banks as EQ2 loans. So meeting their CRA challenges, their Community Reinvestment Act challenges, that was a way they could make a low interest loan to Indian Land Capital Company, and then we would relend it. This year we will get Indian Land Capital Company to about a $53 million business. We've been running just below 10 million. And the banks, 2 of the banks won't lend us any more money to relend because they said we're now competitors. And these are banks that dwarf Indian Land Capital Company. I mean, dwarf it. big national banks and international banks. But it's interesting, they could in fact lend the same way. They lend to the states that through full faith and credit, and they could certainly lend to the tribes that way. The other thing we started working on with the Intertribal Ag Council that we hope will afford the tribes and others the opportunity to benefit from their land. We're doing it through the National Indian Carbon Coalition, which was set up to help the tribes and individual landowners be able to access carbon markets. So here in California, you have one of the largest cap and trade markets. We worked with the California Air Resources Board to understand that some of the provisions they were putting in their regulations on who could access that market just weren't going to fly with the tribes. So having the tribes have to approve all of the projects inside the reservation boundaries was going to limit anybody living in the reservation boundary from probably using the tribal sovereignty in order to do those projects. We got some of that changed. Right now, we've really moved this quite a ways along. We're working with Best Buy and a number of other local entities in the Twin Cities to reduce their carbon market, or their carbon footprint, if you will. It's not about offsetting pollution, specific source pollution, but rather their carbon footprint overall. The other place, when we first started the foundation, we had a long debate about should this particular strategy be using land to help Indian people rediscover their culture, or should it be discover their culture? And during that whole conversation, it finally came down to discover, because as I said earlier, in many cases, we've been so disconnected from our land for so long that we don't even know that culture anymore. One of our very first grants from the foundation went to a tribe in Oklahoma, and they wanted to go back and document their culture. And specifically, they wanted to know why they did an acorn dance when they had no oak trees on their reservation. Well, it turns out they were removed from Ohio. And in Ohio, they had all these oak trees, and that's why they did this oak dance in the fall. And for them, it was kind of a revelation of, well, we've adapted, but we haven't left all of our culture behind. For the most part, we've been moving toward preserving, rather than do some of our other pieces on this particular slide, we've been moving toward getting out there and preserving those places where the tribes still have a cultural interest. This happens to be Peshla. Peshla is the Lakota name. It means the heart of everything. And this is a big prairie in the middle of the Black Hills, which of course was reserved through the 1868 Fort Laramie Treaty, and then subsequently lost during the gold rush. The family who originally homesteaded Peshla once it was open decided they were going to sell the ranch and all the pieces to it. This is one of 5 Lakota sites. It's the only Lakota site that was still in private ownership. And we worked with 6 tribes, 6 of the Lakota tribes, to purchase Peshla and protect it. That piece that you're looking at was subdivided before the auction was to be held into 22 different small ranchettes, and they were going to divide the prairie up. We've maintained it. We've bought more property around it. We also have worked at Bear Butte, which is also in the Black Hills, to protect that from encroachment from the Sturgis motorcycle rally, which by chance happens during pretty much the same time that all of the sun dances occur and prayers occur at Bear Butte. As I said, we work on large buffalo projects because they require large amounts of land, and we can pick up larger pieces of land. The tribes are very much interested in using buffalo, bringing back buffalo onto Indian lands and using those to support the community. We have a 17,000 acre project right now at Rock Creek on the Standing Rock Reservation, which I think will be a model for others. They're putting in a community freezer. They're going to process all their buffalo. Their kids actually own buffalo that are in the herd, and will one of the girls who was there in their beef program first, and then came over into buffalo as well. She is now using it for her tuition to the veterinary school in North Dakota. We work on any number of legal reform pieces, both at the congressional level, but also then at the more local level, especially with state and county. We want the states and counties to understand what it is to have a sovereign tribe in the area and how you can work with them. We also maintain a fairly significant list with legislation that's going on, as well as court cases. At any given time in the U.S. Congress, there are anywhere from 12 to 20 bills pending that will affect Indian land. Court cases are probably 100, 150 at any given time across the country. Out of that 100 and 150, those that get to the Supreme Court, we've had 3. When asking for cert at the Supreme Court, the tribes have had 3 cases accepted, and 1 has been successful. All the rest are counties and states bringing cases forward that get accepted by the Supreme Court. In order to make all that work, we've been trying to work with all of the tribal land staffs across the country through what has become the National Tribal Land Association. And we bring all the tribal land staffs who are interested into a conference every year, and we're dealing with issues and resources that we can bring to them. In fact, that's where our relationship with Raleigh developed. Was Google was doing all of the mapping work, and the tribes obviously had a very high need for getting mapping and getting as many layers on a GIS map as they could get on there. And I was telling her of the one tribe this morning, or this afternoon at lunch. They started with an 8.5 by 11 sheet of paper for representing their reservation, which was somewhere around 150 square miles. And the allotments were just simple red dots on there. They had no idea how many acres were under each one or anything, what the size of it was. And we used Google Maps basically and plotted them out so that they could at least see what they owned. We've been working with families. This is the hardest thing we've ever done. So we're trying to bring families who are co-owners on allotments together to manage their property collectively. We've had lots of families really interested, right? Then they have their first meeting and find out that they aren't in real agreement on much. And so we've had any number of fits and starts under this thing, but we're hoping it's going to work out eventually. All of this led us to, I guess, what was it, 2007. We were at a point where we kept running up against the law that seemed to us to be fundamentally wrong. And so we went out and commissioned a piece by the American Indian Law Resource Center in Helena, Montana. And we worked with legal professors from all over the country who specialized in Indian law. And we went back and looked at Indian law starting in 1829 with the Marshall Trilogy, with the discussion of the doctrine of discovery and the relationship between the tribes who were signing treaties and the federal government. Thomson Reuters published the book, and the principles we developed along the way were in fitting with the United Nations Declaration of the Rights of Indigenous People. So this was our manuscript for how this country could follow that doctrine and come down to a different type of law for Indian land. We shortened it up a whole bunch so that the general public wouldn't have to read that legal version of it. And this is a piece that's also available on our website. and shortens it down to a Reader's Digest version. The last thing I'll kind of go through here, we have proposed to the federal government a social impact bond model for funding the estate planning work throughout the country. You can see in the lower right-hand corner, it would rely on outside investors through a bond process, and then the work would get done through contracts that the Indian Land Tenure Foundation would let to contractors, and then that would be audited and the federal government would pay in savings. We have about 1.3 million undivided interests in this country on Indian land, and each one costs on average $120 per year for the Bureau of Indian Affairs to manage. If you look at the Bureau of Indian Affairs budget, it doesn't have that much money in there for land management. And so we know it's not being done properly, and that's why we're offering this to them. Our reason for doing this was so the Indian people could manage their assets, so that we could get in control of those assets. It turns out, by putting this piece together, as you can see by the pink box down there, the total savings to the Department of Interior would be around $5.7 billion. And they would get an $8.5 return to every dollar spent to do it. Interestingly enough, we aren't sure that's enough for them. And I don't know what is. If they can't get them there in this time of budgets and what they're facing with their employment right now at the Bureau of Indian Affairs, 60% of their employees are eligible for retirement tomorrow. And they're going to be losing this massive workforce. And when we presented this to them, they said, but where will they get jobs? And we said, that's not going to be an issue. You're still going to have plenty of jobs out there. The other thing we're trying to change in the same legislation, the same process. In 2010, independent of everyone else, the department took to Congress a change in the American Indian Probate Reform Act, which said all the permanent structures on trust land should now be considered fee land, meaning they separated permanent structures on the land from the land ownership. And so what we've got in Indian country is this bifurcated ownership. If you buy a house in a city here on a lot, that's connected. By 600 years of real estate law says those two pieces are connected. In Indian country, we've separated that. The unfortunate part is the Bureau of Indian Affairs tracks the trust land underneath, and no one tracks the ownership of the property, the fee property, the buildings. And so we've got people out there selling their trust interests to the department, but not selling their interest in the other property. And that's becoming a real problem for housing and other pieces in Indian country. The other thing, 18 states now, I think maybe even 19 states now, allow for the use of transfer on death deeds. So with simple estates, you can say on the event of my death, so-and-so gets my estate. In Indian country, we can't do that. The federal government has not passed the congressional act that it needs to allow us to do that. When money comes in from Indian land, it goes into what's called an individual Indian money account. Now, some of you may have said, geez, all Indians get a check, right, from the federal government? Well, that's actually their rent money coming to them through the federal government issues by Treasury. That account, the individual Indian money accounts, because the undivided interests have gotten so small and the number of these accounts has grown so large that 50,000 of those accounts have less than $15 in them and accrue less than $1 a year. If they go through the probate process that the federal government has laid out, it costs $1,000 for a expedited probate. And so for $15, we're paying $1,000 in administrative fees to probate that estate. With a transfer on death deed, we could save all that money, and that's what we've pointed out to them. We also want to allow for electronic wills and storage of the originals. So the federal government, at least in Indian country, is way behind the times. And, talking to this group, I'm sure you could get on board with this, right? So they won't accept any electronic documentation of a will. It has to be the original. Now, if you file anything in federal district court, you'll know that you have to do it electronically. They won't accept paper pleadings anymore. It has to be done electronically. But when it comes to Indian wills, they won't accept an electronic will, and we hope to change that just simply so that people can search the database of who wrote a will and who didn't. We've had about 25% of the Office of Hearings and Appeals, the group that does the probate, 25% of that every year is spent on going back and reopening probates that they thought there was no will for, and then somebody said, oh, look what I found. All in all, I think what happens in Indian land, it can be somewhat summarized by this next video. I mean, this is for when he put this, when we had him filmed, I think he pretty much summarized for everybody how we all feel in Indian country.
This land today where I am, this 320 acres, my grandma's original allotment, it means the world to me to be here, to see that my grandma, she herself had a vision to leave something for her kids and keep her line, so to speak, going, her family, and her son, which is my dad, passing it on to us next. And I see the same thing happening with me thinking for my kids. The land is critical to me. Without the land, I'm lost. I won't be me. I won't be excited about doing things. I wouldn't be happy. That'd probably be the end.
Like I said, I think that pretty well summarizes how an awful lot of us in Indian country feel. This is what happens. This is what I feel like after I blaze through 200 years of Indian land history in a 45-minute period. I showed that to some people at the University of Wisconsin, and a professor came up to me afterwards, and I think it was still playing. I didn't realize it was still playing, and she goes, that's the most incredibly disturbing thing I've ever seen, but I can't take my eyes off it. So I'd be happy to answer any questions that folks might have.
So I've been getting a couple of questions from the audience that's watching the live stream, so I'm going to start with one of those. There's a question about, it's actually two questions kind of related. The first is how reclaiming Indian land would impact northeastern Oklahoma, where there's a large population, and they were curious whether there's going to be any additional impact by the ongoing Royal versus Murphy case, which a lot of people might not know what that is.
Yeah, and I would hesitate to say how far out that would go. Let me address the first part, because I think we get that a lot. We get a lot from non-Indians as well. Our goal really is to get back those lands that were promised to us. Now, there are some pieces, especially in northeast Oklahoma, where they did not have traditional reservations. So they had what became known as service areas. And we would still like to get those areas, some lands in those areas, enough to support Indian people and the tribes back in Indian ownership. So yes, we're out there. The one thing I will say, for the most part, we are not looking for the courts or the federal government to return lands to the tribes, unless, of course, the federal government still holds that title. On private lands, we're expecting we're going to have to go willing seller, willing buyer. So we, in fact, help the tribes buy that land back. Will there be an impact over time on an area? What we're finding is wherever there's a large population of Indian people, and this is a little bit of one of those, no generalization is worth a damn, not even this one. I think Mark Twain said that, or Samuel Clemens. Wherever you have an Indian population, you've got a fast-growing population, like mostly young people. And in the plains especially, the population of non-Indians reached a peak generally at the turn of the 1900s. The homesteading had caused this big influx of people into the plains, and it became apparent fairly quickly that you couldn't survive on 160 acres. And so what we've seen in the plains, North Dakota, South Dakota, eastern Montana, Nebraska, parts of Missouri, Kansas, all of Kansas, most of Oklahoma, is that you need large tracts. And what happens is the farmer next door buys your tract, and then he buys another tract, and so we've got these non-Indian landowners who own big tracts of land, and now they're 70 years old and they have no heirs. And so what we're preparing to do is really try and buy those back. And the population in a place like Northeast Oklahoma over time will probably start to expand again. Any other questions?
Just wondering if you could explain, you used the word undivided units or parcels or something?
Yep, undivided interests.
Interests, thank you.
Yep. So when the land is in probate, going from an original allottee, for instance, to the next set of heirs, the land stays intact, but the title divides. And so they're undivided in the sense that there's no physical division of the land, and they own it in common. So probably the best way to think of it is a glass of water. And you each own a quarter of it, but you can't pick out your quarter and hold it in your hand. That's the undivided nature of it. And so what it means in the end is you have to have a process for who makes decisions over that. And we've gotten to the point where the Bureau of Indian Affairs has defined that through U.S. Code 25 as if you've got more than 20 owners, it's 50% ownership has to agree to any action on that. If you've got, I don't know what it is from there, it's like 11 to 20, then 60% have to agree to it. And then from 5 to 11, 80% of ownership has to agree to that action. And if there's 5 or less, 90% has to agree to it, which usually comes down to veto power more than agreement. But that's the undivided nature of it, is you own everything. You can't pick out your part and say that's mine.
Okay, thank you.
Mm-hmm.
Hi, thanks for coming here today. How can I help? Like, how can I get involved?
Well, two things. And first, let me dispense with the one, right? And our development person would be angry if I didn't say you could support us financially. You could do that. I think as important to us and the foundation and Indian people is to become aware of the situation, so that when you hear things like, well, you know, reservations are just a morass of poverty. Well, we have a fair number that are destitute. There's no question. But part of it is because we lost most of the land. And the land that we have left is almost unmanageable because of the undivided interest in the fractionated title. And so if we want to become productive landowners, we need to work on getting that back. Being able to inform your friends and others of the situation. I once said, I'd be happy if we could get to a point where we could show people things like that social impact bond piece and not have people come out of the woodwork to fight us just because we're Indian. You know, I mean, the social impact bond piece serves the taxpayers of this country. It helps us move Indian country further forward as well, and control our assets. And that's what we would like from people, is that they just become informed around some of that.
Thank you again as well for coming. So my question is just in regards to, I know you mentioned that you obviously have Google's help in regards to the GIS mapping and different allocation of the allotments and whatnot, but you also mentioned that only currently, I think you said you have about 7% of wills already written at this point. And I also know you said you are unable to do currently an electronic will. So I guess my question for you is, what's currently the biggest barrier to entry in getting people to participate, or older generations to actually go ahead and write that will, and how can technology and everyone else help in that regard?
The biggest impediment we've had is we haven't had enough people working. So, for instance, we have gone from foundation grant to small grant from the federal government to more foundation grant money to finally 3 years ago we had a grant from the Office of Special Trustee to do 3 years of will writing. But it's been this happenstance of funding to keep people in the field. When we first started, people said, well, Indian people won't talk about death. And in fact, they won't. But they'll talk about where their assets are going. And that's what we wanted them to do. And they're more than willing to do that. We always end up in a 3-year project. At the end of the project, we'll end up with 200 wills in process, but not done. And that's why we want to do the social impact bond, because it's of a scale where we can move. I mean, you write the wills, most of our clients are 65 to 90 years old. And that's why we can't get more than 7%, right? Because we go out and we write all these wills, we go back, we test it. We're probably at 7% because we lost a bunch of people along the way. The wills were probated. That's the nature of the business.
Hi, I saw on your first slide that you said like the goal of the foundation is to reclaim all the land that still retains Aboriginal interests. And I was wondering what exactly that means and how do you determine that? Is it just all the lands that were promised at some point to the Indians, or what is that?
Yeah, the actual language of that is inside the original reservation boundaries. Okay. And so that's the 90 million acres that we lost that were promised to the exclusive use and occupation by Indian people. And then the Aboriginal pieces of that are those places outside of the reservation boundary where they still hold an interest for cultural or religious reasons. But the 90 million is all interior to the boundaries.
Okay, thank you.
Yep. Thank you all very much.
Thank you so much to Cris for coming for this talk. We really appreciate it. Thank you.